Hi friends, today is the ninth session of Law of Torts, and the topic which I am going to cover today is specific torts. The subpart of this session is nuisance, which in Hindi is called upta. So nuisance we will discuss today. So first of all, we should know what is the origin of this word nuisance. Nuisance is originated from a French word which is nuire, N-U-I-R-E, nuire. Nuire's word meaning is to do hurt. So nuisance has been taken from this word, and nuisance is considered as a civil as well as criminal offense, because if nuisance is created in public, it becomes a crime and it becomes a criminal offense. But if the nuisance is related to a person, it's private, then it is covered under the law of torts. So nuisance is of two types, public or private. When it's public, it becomes a crime, and when it is a private, it is dealt as a civil offense under the law of torts. Now, what is the meaning of nuisance? The definition of it. Nuisance is an unlawful or unreasonable interference with a person's use and enjoyment of land, or some other right over or in connection with land. It may include the act interfering with the comfort, health, or safety also, as examples of it or extension of it. So it's clear that nuisance is related to a unlawful or unreasonable interference with a person's enjoyment of land or some other right which is in connection with it. Now let's see some case laws related to nuisance. As we have seen that there exists an unreasonable or unlawful interference with the right of a person related to use of property. So in that case, there is a famous case from Indian jurisdiction which is Radheshyam versus Guru Prasad. In that case, it was held that installation or operation of a flour mill in residential area is a matter of nuisance. So this is an important case because in India, across all the societies, you can find that there exist flour mills in the residential societies. So as per law, if somebody complains about it under the law of tort, it is held as a nuisance to the society. Another case which we have seen in the previous discussion is Usha Bain versus Bhagyalakshmi Chitra Mandir, where the lady has gone to watch a movie and she felt very much disturbed with the portrayal of goddesses in that movie. So that case, if somebody asks, that is not covered under nuisance because it is the hurt of her personal emotions only. Now, there are some features related to this unreasonable or unlawful interference. There is a case where it was held that if there exists a sensitive plaintiff, then if the person who's creating a nuisance, he knows that the person is sensitive and he is a sensitive plaintiff, then what if he annoys him, that is also covered under the Nuisance Act. So knowingly doing an act to annoy a person with regard to his enjoyment of property or land or other matters related to health and safety or comfort in relation to that, such act is also covered under the nuisance. So the case in support of this fact is Robinson versus Gilbert. It's 1889 case. Now the fact of the case is that the owner of a building, he kept some papers which were sensitive sort of papers in the ground floor of the building, and there was a tenant, and the tenant used some heating device and he heated the room with the heater, and because of that heat, those colors which were of sensitive nature, their color changed and the quality of paper was ruined. It was claimed that this is a matter of nuisance, but it was held that the tenant, he was not aware about the nature of sensitivity of paper. He thought it is a normal to use the heater for heating the room in the colder temperatures. So in that case, because the tenant was not aware about the sensitive nature related to the plaintiff, he was not held liable for the nuisance, because in the ordinary pursuits there would have been no injury. But because the plaintiff, his stuff was of sensitive nature and the tenant was not aware about that, on that basis the tenant was not held liable. Another important factor in relation to the reasonable interference is malice. Malice in Hindi is called durbhavna. So the case related to malice is Christie versus Dave. In that case, the plaintiff was a music teacher. She was teaching the music, and defendant was her neighbor. And whenever she started taking the music sessions, the neighbor was creating huge sounds. so that she cannot teach. So this was a matter of malice, and in that case, the neighbor was held liable for the damages to her, or subject to compensation under the charge of nuisance. Now, there are certain exceptions of nuisance also, where it remains excluded. The first exception is prescriptive right. If any person is being enjoyed the land or the property in his possession from last 20 years, it is considered as his legal right. So this becomes a prescriptive right which is based on unobjected enjoyment of the land or property for a period of 20 years as per law of India. Now the second exception is public good or interest. If the person who is charged for nuisance based on his sum of his act, if that act is on public goods or public interest, the nuisance is not applicable. Similarly, if he does some act but from his side he takes a reasonable care in doing that act, any consequences in the result of nuisance also shall not be applicable. So these were the exceptions of the nuisance. We have seen the case law also, we have seen its definition and its origin. So this is all because this is a very small topic. If it comes in your exams or interviews also, it will be just in relation to defining it and referring some of the case laws in relation to that. That's it. So this is all about this lecture. In the future class, we will discuss about defamation, which is also a specific tort. Till then, enjoy the videos and have a happy learning. Bye and take care.